Ladies and gentlemen, our next speaker is a man who studied in Italy and Spain, in Belfast and Dublin. He teaches public law. His research includes the protection of human rights and constitutional reform. Please will you welcome Mr. Cormac Macaulay.
I might be the tallest speaker tonight, so I'll have to turn this up a little bit. Okay, it's very nice to be here in Glasgow. I'm going to tell you something about Glasgow that you may not believe, but every time I've been in Glasgow, the sun has been shining. Which is not what they say in Edinburgh about Glasgow. Let me reassure you. It may also be the amount of times I've actually come here. But as David said, I've been living and working in Edinburgh for the last 7 years. But from my accent, you can probably tell I'm not originally from Edinburgh. I'm from a small place in the northwest of Ireland called Donegal, which has already been mentioned today. I also have a Glasgow story. My grandfather worked here many years ago in the shipyards before he went back to Donegal to start a family. So it's doubly pleasurable to be here in Glasgow with you tonight. I was given a slightly challenging task because you've had this beautiful music and been regaled with great stories, seen some lovely films, and now I have to take you on a journey through some constitutional law. And it's quite late in the night for that too. But I will do my best. When I was given the original brief, I was asked to talk about the Human Rights Act and the current discussions to repeal it. Obviously very topical for tonight's theme. And in doing this, the way I decided to approach it was to set up a series of questions, which this display behind me will ask. And I will try to respond to these questions. And if there are any questions after that, I think we've got some time to address those. The presentation may be some basic for some of you. It may be quite new for some of you. It's quite difficult to explain these things when you don't know who your audience is and level of knowledge. So if it is a little bit too basic for some of you, I do apologize for that. But I wanted to be sure that I was going to bring everyone along with me tonight. If you do have more complicated issues to discuss, maybe we can take them up in the question and answer session afterwards. Okay, so we're going to talk about the Human Rights Act, number 1998. Hey. All right. Sorry, I apologize for those of you standing here. Perhaps you can ask your neighbor what's on the display if you can't see it. The first question is, what is the Human Rights Act? The Human Rights Act is a piece of ordinary legislation which was passed in 1998. It's an ordinary law, it's an ordinary act of Parliament created by the ordinary legislative procedure in Parliament, a majority of MPs voting on a law. And in this way, it's the same and has the same status as virtually any other law that's passed. Whether it be the regulation of roads, or regulation of finance, or finance acts, spending cuts, all that kind of stuff. It has the exact same status as those acts. So it doesn't have a higher level status under the Constitution, which is the case usually with Bills of Rights. That's not the case with the Human Rights Act. It is an ordinary law like any other. And because it's an ordinary law like any other, it can be repealed like any other law. It doesn't require a referendum. It doesn't require a special procedure. In many other jurisdictions where there is a Bill of Rights entrenched in the Constitution, you cannot tinker with that without a special procedure like a referendum or like a supermajority of Parliament or of both houses, whatever else. It's not the case with the Human Rights Act. It can be repealed by a simple majority because it is simply an ordinary law. On to my next question. So what does the Human Rights Act do? At root, it incorporates the European Convention of Human Rights into UK law. What that means is that it makes the rights that are contained in the European Convention legally binding in the UK and enforceable by domestic courts. The European Convention itself, as many of you will know, is an international treaty which was signed in 1950. And all signatory states, including the UK, uphold to do a series of things in signing this treaty. That is to protect the rights that are enumerated in the treaty itself, that are listed in the treaty itself. These rights include the freedom of expression, they include the right to a fair trial, freedom from torture, or prohibitions on torture, right to privacy, freedom of religion, and so on. It also establishes a special court, which sits in Strasbourg. This is the European Court of Human Rights. And under the Convention, when you sign up as a state, you promise to allow not only citizens, but people on your territory to take cases to that court if they feel their rights have been breached. There are a series of hurdles to get to the court. There are a series of things you have to satisfy once you're there. But all states uphold to allow access to that court for all the people on their territory where those people believe that their rights have been breached. And finally, all states who sign the convention, including the UK, agree to be bound by the rulings of that court. So they're upholding a commitment to follow whatever the court decides, especially, well, on whatever human rights issue is present in a particular case. Okay, so how does the Human Rights Act do this? So as I mentioned, the Human Rights Act explicitly incorporates the convention that I just discussed into national law, into domestic law. So it makes them binding in British law, and courts will enforce these rights. This is a significant change, that you can go to a court here in Glasgow and insist on your rights being protected or enforced, those rights that are contained in the Convention. Three main ways this is done. If you go to a court in Glasgow and say that your rights have been violated in some way, the court can interpret all of national law in the light of those rights. So in any case, before any court in the UK, courts must interpret national law in the light of the rights contained in the Convention. If they cannot do this, they must explicitly say so and issue what is called a declaration of incompatibility. This means that if the courts believe that any law of the legal system violates the rights contained in the Convention, they must issue that and say, we believe that this law violates the rights of the Convention. And finally, it gives all of us as citizens rights to go to court if any public body breaches those rights or violates those rights. Any local authority, any public body that we believe has violated our rights in the Convention, we now have a legal right before a court, and a court must hear that. That's a significant introduction with the Human Rights Act that didn't exist prior to that in human rights. It also includes a provision that national courts, when they are enforcing the rights contained in the Convention, must, and I quote here, take into account, unquote, the decisions of the European Court of Human Rights that sits in Strasbourg that I just talked about a short while ago. Significantly, the Act does not give courts the right to invalidate or strike down legislation. That's really important. It's really important from the types of discussions we're having now about repeal, and it also is really important from the point of view of the enforcement and protection of human rights. So what's the relationship between the European Court of Human Rights and national courts? Sorry, it gets a little bit technical, but please bear with me. We lawyers, we like to divide law into two systems, and I like to think of them as two different lanes on a motorway. In one lane, you have national law, and the audience and obligation of national law are ourselves. That is our relationship between us and the state, right? If we believe the state has breached our rights, we have an action against that state, and we enforce those rights by going to court ourselves, right? On the lane beside it, we have what we call the international legal system. And that is the relationship between states themselves. They sign agreements amongst themselves. If a state is deemed to have breached that agreement, the only people usually who can have recompense are other states, right? So the audience for that particular system are other states. And that includes the European Convention of Human Rights, right? When states sign the European Convention, they are promising to other states that they will uphold those human rights within their territory. If they don't do so, it is other states in the international system which would enforce effectively our rights, right? What the Human Rights Act does is it allows the international to cross over into the lane of the national, right? So it takes a law, an international law, enforceable by states, and makes it effective in national law. So it's essentially crossing over from one lane in the motorway to the other lane in the motorway. Okay? It gives, the Human Rights Act effectively gives permission for that crossover to happen. Okay? This is significant for a couple of reasons. First of all, what it means is that these two systems operate in parallel. Right? The Human Rights Act did not create the Convention. The Convention and the Court were there before the Human Rights Act was even dreamt of. Significantly, repealing the Human Rights Act will only have effect in the domestic lane of the motorway. The European Convention will still exist. The European Court will still exist. It will still hear cases against the UK where they are brought. And it will still be binding in international law, in the international lane of the motorway. It will still be binding on the UK, even if the Human Rights Act were to be repealed or replaced. And that was indeed the position prior to the enactment of the Human Rights Act in 1998. So that's the kind of more technical stuff about what the Human Rights Act is and what it's about. Now we move on to the slightly more political debates that are going on at the moment. What is the problem with the Human Rights Act? There are 4 arguments that the Human Rights Act are problematic, or at least 4 arguments that I could make sense of. There are lots of arguments about the Human Rights Act. A lot of them don't make any sense. For a lawyer, the 4 arguments that at least make some sort of sense are these. First of all, courts should not be telling democratically elected politicians what to do. That's the first argument, right? An argument from democracy. Secondly, a foreign court should not be deciding sensitive issues of national policy. And it can do this through the Human Rights Act, like I already said. National courts must take into account the decisions of the European Court of Human Rights. So in that way, the European Court of Human Rights does have some influence on how rights are protected here in the UK. And the argument is that this foreign court, which sits in France of all places, shouldn't be making decisions on things that they essentially know nothing about, that is domestic issues, domestic policies, and so on. Thirdly, that the Human Rights Act has led to quote-unquote bad decisions. And I'll go into that in a little more detail. And finally, that the European Court of Human Rights unfairly targets the UK in the international side. So if you go back to the 2 lanes on the motorway, in the international lane of the motorway, there's an allegation that the European Court of Human Rights unfairly targets the UK. There are too many cases against it, and it's being singled out for kind of bad treatment in that way. Are they right? I'm a lawyer, so I'm going to say, well, on the one hand, on the other hand. With regard to the first question, democracy, courts shouldn't be telling politicians what to do. There is an issue in constitutional law about the relationship between courts and legislatures, right? There are good arguments, I think, for having courts. We want our decisions to be made, at least legal decisions, to be made by impartial bodies, by neutral judges who don't have an interest in the case themselves, right? This lives up to things that we think about are good, like justice and the rule of law, impartiality, objectivity. These kind of militate towards having court systems, right? This is why we have courts, this is why we have the independence of the judiciary, so that's a good thing, right? On the other side, we also think democracy is quite a good thing. We think it's quite a good thing that we can vote for people who make decisions about how the country is run, about whether to go to war or not, about whether to cut the deficit, about many, many other things. We think it's probably good that we as citizens have a stake in that, in those types of decisions, and they're not made by some distant body that doesn't reflect our interests or doesn't reflect what it is we have to say. Now, these are 2 noble and very respectable ideals, I think. On the one hand, you have justice and the rule of law. On the other hand, you have democracy. The problem is that they are in tension, and they are always in tension, right? Unfortunately, it's not a perfect world. We can't have pure democracy without some cost to justice and the rule of law and human rights. On the other hand, we can't have justice, the rule of law, and human rights protection without some impact on democracy, right? All constitutional systems have this tension. That's what constitutional democracy is about. The constitutional is in tension with the democracy, right? And every system has to work out those tensions in different ways. There is no right answer. It will never go away. It's something we have to live with. right? That's just the way life is. These are things that we want. We think they are good, but they are in tension, and we have to just accept that. Significantly, it's an inevitable feature of British constitutional law, and the Human Rights Act will not make it go away. Repealing the Human Rights Act will not get rid of the tension between democracy and human rights, or democracy and constitutional law. It exists in other parts of the legal system, and it will continue to exist in other parts of the legal system, because that is essentially how we want it. We want constitutionalism, but we also want democracy, and they're always in tension. The Human Rights Act is just one example of that. So I think it's important to be aware of that, or to bear that in mind when you hear these anti-democratic arguments about human rights and the Human Rights Act, that it's just a tension that is there. It doesn't mean it's not a legitimate argument to say that democracy, human rights in some way compromise the democratic will. To an extent, that's true. The point is, it's only one side of the story, right? So they are kind of right in saying that, yes, Human Rights Act in some ways may be interpreted to compromise democratic decision-making, but that is just the tension that's there, and it's up to politicians and judges to work out that tension, and it changes over time. Sometimes it goes more in favour of democracy, sometimes it goes more in favour of human rights, but it will never go away, okay? What does this have to do with the Human Rights Act? Well, the Human Rights Act is a little peculiar in this debate, because the types of debates we have about constitutional democracy, constitutionalism on the one hand, democracy on the other, usually relate to situations where courts can invalidate or strike down legislation. So take, for example, Germany, the German Federal Constitutional Court, or the US Supreme Court. If they find that any law violates the Bill of Rights, they can effectively rub it out. They can obliterate that law. It no longer exists for all intents and purposes, right? This obviously is a cost to democracy, because it is democratic bodies that made these laws, and so the issue is more pronounced there. The Human Rights Act does not contain this power. Courts do not have the power to strike down democratic legislation, and that's an important point, I think, when we think about these tensions. All they can say is, we think this law is not compatible with fundamental rights, and then it is for Parliament to do what it wants with that. Courts do not, and there are several provisions of the Human Rights Act which say the courts do not have the power to strike down legislation. They cannot invalidate laws, right? That's a significant point, and a significant point to remember when we're thinking about the tension between the goods that we like, democracy and justice, democracy and human rights. On to the foreign judges point. So the other critique that I talked about, that the European Court of Human Rights is a foreign court in a foreign land with foreign judges. It's important to think about the impact that the European Court of Human Rights has through the Human Rights Act. The Human Rights Act, as I said, requires courts to take into account the decisions of the European Court of Human Rights. What take into account means is essentially in the eyes of the beholder. Its meaning has changed over time. It could mean anything from, yes, we understand what the court has done here, but we want to go our own way. We have taken into account, but we're going to go and forge our own path with respect to what freedom of expression means. Or it can mean slavishly following everything that the European Court of Human Rights says. Right? There's quite a large scope of interpretation there. And what we see in what the courts here have done is that they have kind of gone up and down on it. They started almost always following Strasbourg to the letter. Whatever Strasbourg said, the national courts did. But in more recent times, they've started becoming more independent and saying, okay, well, we understand that's what Strasbourg said, but we don't think it's appropriate for this case. We don't think it's appropriate for our law. We don't think it's appropriate given the context of the British Constitution, right? So foreign judges telling national politicians what to do is sort of true, but it's a little bit more complicated than that. It's up to the courts to patrol exactly how much influence the European Court of Human Rights has under the Human Rights Act through this provision of taking into account. The ECHR itself, just to talk a little bit about the court, yes, it is a foreign court. Yes, it does have foreign judges. Every signatory state to the court is entitled to nominate one judge, so we have 48 different judges from 48 different jurisdictions. The usual complaint is they know nothing about British law. They know nothing about Scottish law. Most of them probably don't. I think that's probably fair, in the same way that our judges here don't know a lot about Maltese, well, maybe Maltese law, but not Latvian law or Romanian law or Russian law. However, there is a huge army of legal specialists that sit in Strasbourg and work with the judges, one of whom I know personally and one of whom comes from here, from Glasgow. And wherever there are Scottish cases in the Strasbourg court, he is one of the people called upon to explain the peculiarities of Scottish law to many of these foreign judges. There's a huge library and a huge cadre of specialists who explain to courts from judges from different countries what each national system is about and how the best way to interpret human rights in that context. So while it is true that there are foreign judges, they're not completely ignorant of national specificities and national contexts. Also, finally, I mean, yes, it is a foreign court with foreign judges, but it is also what the United Kingdom did sign up to in an international treaty. So they did promise with all their peers, their other states, that they would abide by the rulings of this court. So they have put themselves under a legal obligation to say, we will follow what the court says. And then to come back after and say, yeah, but it's full of foreign judges. It's like, okay, but you did sign up to this, right? Does the Human Rights Act lead to stupid decisions? What about the cat? Okay, first of all, as many of you might know, human rights don't have, put it euphemistically, the best press in this country. I saw some politicians saying, you know, we deeply care about human rights. Many of the politicians who are proposing to repeal the Human Rights Act. And part of the justification is that human rights have got such a bad press that we think something needs to be done to restore the importance and dignity of human rights. It's a little bit rich because many of those politicians are responsible for giving human rights a bad press. And I did take one of them, a Conservative Party member who shall remain nameless, an MP, who said this at a conference, and I stood up and said, well, this is kind of your fault. He didn't really have an answer to it, he just kind of sat down with a big red face. But so we don't have a very good press. It can be difficult to get good information on human. Well, it's not that difficult actually. If you look on the internet, there are a lot of good resources. The problem is we're very busy, most of us. We don't have time to sit and research. Well, it's my job, so that's okay. I do have the time to do it, but you people have other things to do with your lives, and so we get a lot of information from the press and kind of rule of thumb ideas about how things work. And depending on the information you get, your knowledge of the way the human rights is communicated is not necessarily great. So let's start with the cat story. It's the cat. Some of you will know this. Some of you won't. It's in 2011, Theresa May made a speech, the Home Secretary, at a Conservative Party conference. She rattled off a list of problems with the Human Rights Act, one of them being, and I quote, the legal immigrant who cannot be deported because, pause, and I am not making this up, pause, he had a pet cat, pause for laughter. This was complete rubbish. It actually had nothing to do with the Human Rights Act. It had to do with the arcana of administrative law and a government department failing to follow its own guidelines on deportation. So the facts are not always given straight, and especially not by maybe those people who we think should be giving us good information on these questions, such as politicians. So the cat story is bogus. I mean, there was a case of, and the judge did mention a cat, but it had nothing to do with the Human Rights Act. Okay, but what about the Iraqi criminal cases, other cases? It is true, and this is a case that's made a lot of headlines. In 2003, an illegal immigrant from Iraq, he applied for asylum and he didn't get it, stayed illegally in the UK and committed a series of crimes. One of them was a very unfortunate one, where he's driving without a license and he was involved in an accident in which a little girl was killed. I read the story today in the Daily Mail again, just to refresh my memory. It's always a fun experience reading the Daily Mail. And I read the story in the Daily Mail, and then I went to my sources. And you know what the Daily Mail says? It's kind of true, but not really completely true. It's a little bit like watching. Have you ever watched Russia Today? You know, this Russian TV channel. some of it's kind of true, but maybe not always completely true. And I had that experience reading the Daily Mail. It is true that he did commit these offences. It is true that he was involved in. He was driving a car, which ultimately involved in the death of a little girl. And this happened in 2003, there were some other offences, and then in 2008, the government decided, okay, enough's enough, you're going to get deported. In the deportation hearing, he said that he had a right to family life because he had a partner in the UK. I don't think they were his children, but he had adopted them, and he had a kind of a social network and a family situation which he said would be disproportionately violated if he was deported, and the immigration judges agreed. So it is true that a petty criminal was allowed to remain in the UK because he had the right to family life, but it was a delicate balance run by an immigration court that said, on balance, the strength of your family ties outweigh your deportation. So if you were deported, your children wouldn't get to see you, this would be a disproportionate effect on them and so on. Crucially, and something the Daily Mail left out, was that in the car accident in which the little girl was killed, he was not found criminally liable. So under the criminal law, they found that it was not his fault that the girl died, right? It was a set of circumstances that he was involved in, which involved the little death of a girl, but he wasn't convicted of murder and he wasn't convicted of manslaughter. And so that crime, he was convicted of basically driving offences on the facts, right? So always when you read these things, it's good to dig into the facts because you're not always getting the full story about that case. But even if you disagreed with that decision, and I read lots of decisions that I disagree with all the time in my job, even if this was more straightforward and less complex than the Daily Mail reported it, even if it was a bad decision, I think there's something about reporting in human rights, and it's a way of communicating information that makes us form opinions that are not maybe that entirely close to the truth. I've kind of referred to it, but when we think about what to believe and we think about questions of truth, anecdotes are very, very powerful, right? Telling a story. If you're explaining, I say this in class when something's really complicated. Let me give you an example, right? Here is A and B and this happened and this kind of stuff, right? It's a very powerful way of getting information across. The problem is when life is more complicated, and it usually is, and human rights are certainly more complicated, you're only getting a very, very partial version of the truth, right? So to take, even if, say, the Iraqi criminal case was decided differently, and you hear that story and you think, oh my God, the Human Rights Act is like the worst thing ever, right? If there are 99 other cases that are not like that, then you're not necessarily getting a full picture, right? If you get one bad decision that's sensationalized, and there are 99 others that are not, it's not really true to say that the Human Rights Act is causing bad decisions, right? Well, it may not be true, but what we should do is look at the evidence, right? We should look at all the cases and say, okay, I think there are a handful of bad cases there, but on the whole, most of these decisions are quite sensible, right? And the approach taken to communicating information about the Human Rights Act, I think a lot of the times in the media, relies on this anecdotal story, right? Here's a tale of woe that I'm going to tell you and try and make you believe my position that the Human Rights Act is bad or creates bad decisions. When really we should be looking at all the cases and saying, okay, statistically, are there a series of bad decisions coming this and can they be attributable to the Human Rights Act? Of course, statistics are boring and don't sell newspapers, right? So we know why that happens. Okay, so when we just think about whether the Human Rights Act leads to bad decisions, we need to think a little bit more beyond the tale of woe. We need to think a little bit harder than just the one story about the bogus story about the cat, the true story about the little girl who died at the hands, sort of an illegal immigrant, but not form our entire belief on that to answer that question. We need to look, I think, a lot more in the round and look more broadly. The final criticism, there are too many cases decided against the UK. The UK is being singled out by the European Court of Human Rights. First of all, this has nothing to do with the Human Rights Act. but a lot of our politicians don't realize this. They are, in the words of a colleague of mine at Cambridge, legally illiterate. So they attack the Human Rights Act with this. But if you remember my little kind of metaphor of the two pathways in the motorway, the Human Rights Act is in the domestic one, right? The UK is in the dock in the international one, right? So it has not got anything directly to do with the Human Rights Act, if it is true, right? The good thing about this kind of charge is that unlike cases which we can decide and they're complex and we have to read them, we have a lot of statistics about this, and we have a lot of very good statistics about it. And here are the statistics that I've got. In a period of 55 years, there have been 22,782 applications taken against the UK. Right? Applications are simply the first thing you do. You send your case to the Strasbourg court, and then it gets processed. Most of these never make it to the court because they're thrown out for all sorts of different reasons. They have nothing to do with human rights. They didn't follow the correct procedures and so on. Out of those 22,782 applications, there have been 513 judgments against the involving the UK, right? So you can see the massive drop from 22,000 applications. Only 513 of those actually made it to judgments before the court. All of the rest were thrown out, or never made it to judgment for all sorts of different reasons. And of those 513 judgments, 301 were decided against the UK. So the UK lost in that. That's an average of 5 cases a year in a 55-year period. In terms of applications, that is 1% of the cases that initially start as applications, right? So the amount of judgments that are against the UK in the European Court of Human Rights, 1% of them are decided against the UK. In terms of actual judgments involving the UK, that means 60% are lost and 40% are won. Now you can look at that negatively or positively. Positively, there aren't the figures aren't as stark as we might otherwise think. Negatively, we might think, God, I thought we could do better than that, right? 60% of cases against is not necessarily a good figure. I'll leave it to you to decide whether you think those statistics warrant the kinds of claims that the European Court of Human Rights is singling out the UK. But it's not the worst offender. There are other countries who come higher in the table of offenders. But it does shed some light, I think, on these types of things that we hear that the UK has been singled out for special treatment. So, to quickly, before I finish, where are we now? Where are we in the process about repealing the Human Rights Act? The coalition government launched a consultation on the Bill of Rights, which some of you may remember, which reported in 2012. It decided that, yes, there should be a Bill of Rights for the UK, but that the time was not ripe to do it, mainly because of an impending independence referendum, among other constitutional issues that needed to be ironed out. And what the panel said was, we do think on balance there should be a Bill of Rights and it should replace the Human Rights Act, but that's something for another day. It's not the time to do it now. After the general election, this became a main commitment of the current government, the Conservative majority. They were going to repeal the Human Rights Act, come hell or high water. They were going to do it very quickly, within the first 100 days of the government. Then they were going to do it by autumn when they would produce their consultation document. That's autumn 2015. We heard from Michael Gove last week that they're really, really going to do it. Still really going to do it super quick. We still don't know. We still don't know what's going to happen, because this has been the can has been really kicked down the road, and we've gone from we're going to repeal it tomorrow to yeah, okay, we're still thinking about it. What we do know is that the UK will not withdraw from the European Convention of Human Rights, or at least this government will not seek to withdraw the UK from the European Convention of Human Rights. That's the international stream I talked about and the court's jurisdiction. We have been informed on 2 levels that the reforms to the Human Rights Act itself will be minimal. We had Michael Gove before the House of Lords last week singing the praises of the European Convention of Human Rights and the rights that it contained, and that it was a great idea and that these were British innovations and so on and so forth, which led one pointed remark from one of the committee to say, well, why the hell do you want to repeal the Human Rights Act? For which, for my money, Michael Gove didn't have a very convincing answer. I have been in a consultation with his Undersecretary Dominic Raab, in which I posed the same question. I said, if things are so minimal, why do you want to repeal the Human Rights Act? And I wasn't given a particularly good answer there either. I think what we're seeing at the moment is human rights have been turned into political football. There's a sense in which Labour got to do this, so should we. We're living with Labour's law, and we want our own one. I don't think it's a good way to talk about human rights. I think human rights are complicated things. I think they're things we should all get involved in talking about. I don't think we should always believe judges. I don't think judges always get it right. But I think when we talk about human rights, and especially when we talk about whether we should repeal the Human Rights Act or what kind of protections we want for human rights in society, it should be the process of an open, deliberative engagement, particularly with the public, about what we think freedom of expression means in our society, and not done at the behest of party political point scoring. I'll get off my stump now. So just to wrap up, for those of you who want to know more, please visit this website. It's a website run by a human rights barrister in London. It's called rightsinfo.org. It's a very simple web address, rightsinfo.org. It has excellent information on human rights, both at the European level and at the Human Rights Act level. It explains things with nice graphs and things that, had I better technical expertise, I would have tried to give you here tonight. But if you do want to find out more, please do visit this website, because they do have fantastic information, neutral, impartial information about the Human Rights Act. So I think we're going to take some questions. Is that right? So I'm done.
So what was the situation between the signature of the convention and the human right of 98? If it were repealed, would we go back to that? What was it?
Right, so the situation between 1950, well, it's a little more complex, but we'll say 1950 for ease's sake. Between 1950 and 2000, when the 1998 Act actually came into force, was you couldn't enforce human rights in British courts. You could go to court and claim it, and what the judges said is, well, it's not law, it's not national law, it's international law, and it's for the UK as a government outward facing to decide what it wants to do about it. So you could go to the court, to Strasbourg, but that was quite a long journey. You had to go through national courts, and then you had to go to Strasbourg, and you had to get counsel together, and you get your application together, and the case could take anything from 3 to 5 years to be decided. So we did have lots of cases against the UK in Strasbourg, in the international lane that I talked about on the motorway, but it wasn't a very efficient process. It was quite slow, and one of the reasons, the justification the Labour government, well, at least they claimed, that they implemented the Human Rights Act was to stop that, was to sort out our human rights issues at home, so that more people would get their human rights protected more quickly at home for less cost, and it's better to have this sorted out at home rather than it going to Strasbourg, where there's an international audience, international media looking at the question. So you could have your human rights protected before the Human Rights Act, but through an arduous journey all the way to Strasbourg. You couldn't do it here in Glasgow before a national court. There was a question, yeah.
Thank you. My question was going to be similar. I was going to ask, if the Act is repealed, what situation will the UK be left in terms of human rights legislation? Will there be a vacuum? Will we be diminished in terms of protection of human rights?
Yeah. Well, because the current government has been so super quick in implementing its proposals, we have no idea. What we do know, and at least what the Justice Secretary has promised, is that it will be quite similar to the Human Rights Act. So basically, the Human Rights Act will be on the statute books. It takes another law to get rid of it, right? You can't just rub it out. You have to introduce another law to Parliament which explicitly repeals the Human Rights Act. But they're not proposing just to do that. They're going to replace it with what they're calling a British Bill of Rights. The content of that bill apparently is very similar to the Human Rights Act. So we will assume we will have a similar type of situation. There will be some changes, things like, apparently we value more the freedom of expression in this country than rights to privacy. So there will be a provision saying if there is a conflict between the two expression should prevail in those types of situations. Michael Gove has also suggested, well, he said that he doesn't want the Human Rights Act to apply to the activities of the armed forces, both to victims of the armed forces, because there are a couple of cases of people in Iraq who took human rights cases against the British Army and won for violations of their rights, but also against the military personnel themselves. So soldiers have taken human rights cases against the military for violations of their rights. And one of the big changes is that they want to stop that. They want to stop the Human Rights Act applying to the activity of the military.
Sorry, different question. You mentioned now Bill of Rights, and am I right remembering at the beginning of your presentation you said that Bill of Rights has a higher category than an act? Is that a benefit of the change, or can you explain a bit more on that?
No, it's not. Generally Bills of Rights do have that status. In this case, the Bill of Rights is just a name. It will still be just another act. Often the Human Rights Act is called a Bill of Rights for Britain because it's considered to be a Bill of Rights. There is a historical Bill of Rights from 1689, which I won't go into, but it won't change its status. It will be a normal act like the Human Rights Act, which means that we could have, in the future, an SNP majority government in Westminster which repeals the British Bill of Rights and reintroduces the Human Rights Act. We don't know. But it will have the same status. It will be an ordinary act, notwithstanding the official title of a Bill of Rights. Great. Well, thank you for your attention, and good time for my train for Glasgow.